Thank you, Professor Pitts, for that very kind introduction. Thank you all for coming out tonight. It's great to see so many of you here. It's great to see some familiar faces in the audience. As Professor Pitts mentioned, I taught here at UCCS for 10 years. And my years here with the students and the colleagues, I will cherish all of these memories for a long time. I really loved my time in Colorado Springs. It's a real pleasure to be back. And it reminds me of what I left. So I live in a very remote part of Michigan now that doesn't have mountains, that doesn't have a lot of great hiking, that doesn't have anything resembling the kind of restaurant scene you have here in Colorado Springs. So I'm going to make the most of my time here while I'm here. It does have a good college, Hillsdale College, and so I'm delighted to be there, but really grateful for the opportunity to be back here and to speak with you all this evening. I do want to say Professor Pitts gave me a really tough assignment. So we were talking about the topic of tonight's talk several months ago, and Professor Pitts said, why don't you talk about DOGE? I know that you like to talk about the administrative state, but let's talk about something that's going on right now. And let's use DOGE as kind of a segue to talk about this broader question. I thought that was a great idea at the time. And when I was getting ready to speak tonight, I had to try to take a catalog of everything that the Trump administration and DOGE are doing with respect to the administrative state. And I will tell you, it's a very difficult thing to talk about everything that's happening. I don't have all night, and I'm not going to bore you by going on at length, but I will say that in a short span of time, it's really hard to describe to you how much has changed and in how little of a time it has changed. And so if you're looking for a short answer to the question posed by tonight's lecture, did DOGE make any difference? The answer is yes, it has made a big difference. And I will use the first part of my talk tonight to describe exactly what I mean by that. But there's one caveat, which is a lot of this stuff is in the courts, and we really don't know right now how this is all going to play out. Okay, it seems like we're living in a time of great upheaval. I'm sure you all feel something of that. Compared even to President Trump's first term, some of you may know that one of his closest advisors, Steve Bannon, very early on in the Trump administration's first term, pledged the, quote, deconstruction of the administrative state. That was one of the goals of the Trump administration's first term. But even compared to the first term, what's going on in this term seems to be much more rapid and much more aggressive in terms of the attack on the administrative state. We read that the Department of Education is being dismantled, that agencies are being deconstructed left and right, and some of these agencies have been around for a long time. So to what extent is this deconstruction of the administrative state actually happening? And maybe a bigger question, what is the administrative state? What exactly are we talking about here? How does the administrative state work? What is it? And what are the constitutional issues that it raises? I will try to shed some light on all of these questions in a short period of time, and I really look forward to the conversation that will follow and the questions that you'll have. Okay, now the apparent origin of much of this controversy is the so-called Department of Government Efficiency, known by most simply as the DOGE. This truly is the 21st century in American politics. We are ruled by memes, and DOGE is the meme right now in American politics. Now, we heard a lot more about DOGE in the first few weeks of in the early weeks of Trump's second term, but we've heard a lot less about it in recent months because, as many of you know, the two leaders of DOGE, Vivek Ramaswamy and Elon Musk, have parted ways with the president, the latter quite prominently over the big, beautiful bill. But let's start with these preliminary questions. What is DOGE? Where did it come from? What authority does it have? And then is something like this unprecedented? Okay, so what is DOGE? DOGE was established by an executive order on the first day of President Trump's second term. That executive order renamed an agency called the United States Digital Service and renamed it into the United States DOGE Service. So this executive order repurposed an existing agency and turned it into the United States DOGE Service. and established DOGE within that agency as a temporary organization. This is a specific classification under federal law. DOGE is a temporary organization. It will expire on July 4th, 2026, the 250th anniversary of the Declaration of Independence. The same executive order that established the United States DOGE service set up DOGE teams in every administrative agency with at least 4 people in every agency to coordinate with DOGE in implementing the president's agenda. So there are DOGE teams inside of all of these other agencies working with the DOGE service. Is this an unprecedented thing? The answer is it's not. It is not actually that unprecedented. If anything, the DOGE follows a long tradition of presidential commissions to eliminate waste, fraud, and abuse. I'll give you a few examples. Dwight Eisenhower established something called the Rockefeller Committee, composed of people who were not compensated by the government, to restructure the executive branch and eliminate wasteful programs. Franklin Roosevelt established something called the Brownlow Committee, which was a committee that was supposed to and did promote sweeping reforms to the executive branch. The Brownlow Committee is famous for being a very aggressive attempt to restructure the executive branch. President Truman established the Hoover Commission, led by the former president, Herbert Hoover, to eliminate waste, fraud, and inefficiency in the federal government. The most interesting example is President Clinton's commission. I call it the Gore Commission because it was headed by Vice President Al Gore. It was formally titled Reinventing Government. This commission, established at the beginning of President Clinton's first term, proposed over 1,000 regulatory reform actions aimed at saving $100 billion. And by the time that the second Clinton term came to an end, the Gore Commission cut 16,000 pages of regulation and over 350,000 government jobs. Now, I stress, this was the Clinton-Gore Commission, not the Reagan Commission, not the Nixon Commission, right? So it's not extraordinary or even that uncommon for new administrations to set up something like DOGE. But DOGE feels different, doesn't it? It doesn't feel like any of these previous examples. Now, I think that's because there is something actually different about DOGE. Its goals are more sweeping and more fundamental than any of those predecessors that I've just mentioned. Previous commissions aimed to eliminate wasteful programs and cut unnecessary regulations. DOGE is not just about eliminating waste, fraud, and abuse, even though that's often used as a justification for the creation of DOGE. In his statement that announced the creation of DOGE, Trump said this: DOGE will dismantle government bureaucracy, slash excess regulations, cut wasteful expenditures, and restructure federal agencies. Now, 2 of those goals, slashing excess regulation and cutting wasteful expenditures, are totally consistent with the previous commissions that I just mentioned. It's the other 2 goals, dismantling government bureaucracy and restructuring federal agencies, that set the DOGE apart from the previous commissions. The attempt to dismantle and restructure the modern state is more ambitious than anything attempted since Richard Nixon was in the White House. And if you're looking for an analogy to what the DOGE is doing and what its ambitions are, President Richard Nixon is the perfect analogy. I can say more about that after I'm done with my remarks in some conversation, if you're interested in that comparison. But this background to the DOGE and other related commissions kind of gets to the core thesis of my remarks tonight. And this is really the upshot of what I want to convey. The Trump administration is seeking to fundamentally reform the administrative state. But it is doing that because it believes, with good reason, that the administrative state poses a challenge, a serious challenge, to basic principles of American constitutionalism. The Trump administration wants to reform the administrative state because the administrative state has for a long time really threatened basic principles of the American Constitution. Okay, well, before I get to that thesis, let's at least try to provide some sort of survey in response to the title of this talk: Has DOGE made any difference? The answer to that question, as I mentioned, is, I think, an obvious yes. If we look at the whole of what has happened, and with the caveat that we don't know what the courts are going to say about all of these things. Okay, so as I mentioned, when I got ready for this talk, I had to think about summarizing everything that's been going on over the last 8 months, and that's a daunting task. But I think that there are four areas that we can, four categories we can emphasize to try to make this as simple as possible. DOGE and the Trump administration more broadly are cutting spending, repealing regulation, firing federal employees, and asserting presidential control over the bureaucracy. So I'll cover each one of these very briefly. Cutting spending, repealing regulation, firing employees, and asserting presidential control over the bureaucracy. So let's start with the spending cuts. Very prominently, Elon Musk said that DOGE was going to cut $2 trillion of federal spending. Now, if you know much about the federal budget, cutting $2 trillion out of it is an enormous part of the federal budget. He was never clear about whether that was going to be done annually or cumulatively over a number of years. But either way, most of us commented on this prediction by dumping a lot of skepticism on it. Even Musk seemed to realize that this was an over-exaggeration of what DOGE could accomplish. So by early January, before Inauguration Day, Musk backpedaled to $1 trillion. Said there was a good shot at cutting $1 trillion. Now, if you go to the DOGE website today, and there is one, there is a spending cuts tracker on the DOGE website. The administration claims $206 billion of estimated savings. But most of this is related to canceling contracts with and grants awarded to the private sector. A very small portion of the spending cuts involves the president's authority to rescind funds that Congress has appropriated. Under a major law passed in 1974, this is the major budget act that sort of governs the federal budget process. The president is allowed to cancel funds that Congress has appropriated to various programs. But when the president does that, he has to send a message to Congress, and Congress has 45 days to approve the cancellation. If Congress does nothing, the spending happens anyway. So president can rescind or cancel funds that have been appropriated, but the Congress has to approve it. President Trump has used this authority once. He canceled $9 billion. That is far less than $1 trillion or $2 trillion, $9 billion of federal spending, and Congress approved that rescissions package in July. In so doing, they also canceled my only chance to appear in a PBS documentary. But that's a story for another time, or maybe after the lecture. So I was quite disappointed by that decision. DOGE's, there's an interesting controversy right now about pocket rescissions. If you've heard about this, we can talk more about it after my remarks. Trump is trying to use the end of the fiscal year as a way of letting the clock run out without Congress actually approving the spending cuts. That will certainly be litigated and he has already proceeded to test that theory. Okay, so in short, DOGE's quest to cut spending is not finished. Very clearly, there is more coming. But so far, it has not even come close to the $2 trillion or $1 trillion that Elon Musk has promised. Okay, what about regulations? The administration has been aggressively repealing regulations. And there's an executive order promulgated in April where the president said, we can repeal a whole bunch of regulations because there have been these 10 Supreme Court decisions that authorize us to move forward with cutting regulations. There are a lot of legal questions around his use of these 10 cases as support for repealing regulations. We can get into some of those details later on. But in the interest of time, I'll cover 4 of the more controversial repeals. So the first is the repeal of the Obama administration's showerhead rule. I don't know how many of you have followed the showerhead controversy. President Trump has promised to make America's showers great again. That is a direct quote. You shouldn't be surprised. That is a direct quote from the president. Congress passed a bill in 1992. This is something I applaud. Congress actually made the law in 1992 instead of delegating that power over to the Department of Energy. The 1992 bill mandated a 2.5 gallon per minute flow of water for shower heads. So you might notice this, right? Your shower head always has a 2.5 gallon per minute flow maximum. The question is, what is a shower head? And most of the controversies in administrative law really revolve around such questions. What is a shower head? What is a stationary source of pollution? What is an essential health benefit? And in this case, the Obama administration said, well, look, if you have a shower with a bunch of nozzles, which we all know these exist and they're increasingly used, is each one of those a shower head? And can each of them have 2.5 gallons of flow? Or is the whole thing one shower head, and you have to have a 2.5 gallon per minute maximum cumulatively out of all of the shower heads? The statute doesn't say, Congress didn't anticipate this problem, and so the Obama administration said, it's all one shower head, 2.5 gallons maximum per minute out of the whole thing. Trump and many of his supporters despised this rule, and so Trump ordered the Department of Energy to repeal the definition and, as I mentioned, quote, make America's showers great again. That is in his official statement. Now, typically, and apologies for getting into a small technical detail here, administrative agencies like the Department of Energy can only repeal rules if they go through something called the Administrative Procedure Act. This is a law passed in 1946, which basically serves as the constitution of the administrative state. It is almost like the fundamental law of bureaucracy. And there's a set of procedures in the Administrative Procedure Act for what we call notice and comment rulemaking. And as the term implies, agencies have to issue a notice before they make a new rule, they have to get comments from the interested public, and then they have to justify their rule with a statement of basis and purpose once the rule is finished. The interesting thing about the showerhead repeal is that Trump said in the executive order, quote, notice and comment is unnecessary because I am ordering the repeal, end of quote. So the Trump administration is saying if the president does something, the Administrative Procedure Act doesn't apply. And that's going to be an important legal controversy about the showerhead rule. Watch for the media's description of that when it gets to the courts. Okay, the Trump administration is going through notice and comment to repeal the other three rules I want to talk about. The first is something called the roadless rule. And I think as you go further out west, more people are familiar with these rules I'm about to describe. The roadless rule is a Forest Service rule that limits the building of new roads on public lands. The Trump administration is proposing to repeal this rule because in the administration's view, the rule inhibits responsible forest management, especially the mitigation of wildfire risk. It's harder to mitigate wildfires if you don't have roads that get into public lands in order to address questions of forest management and also wildfires after they break out. The Forest Service is currently taking comments on the proposal to repeal this rule. The Public Lands Rule is a Bureau of Land Management, BLM regulation that governs leases on the land under the agency's control. So the Public Lands Rule was finalized by the Biden administration last year, and it said, if you want to lease out the land, if the government wants to lease out the land for conservation, that will be treated as development. This obviously took a lot of the public lands out of being leased for mining, logging, grazing, and other forms of economic development. Many interests surrounding, many ranching interests really opposed the Public Lands Rule, and President Trump has proposed to eliminate this rule and then make it easier for public lands to be used for economic development. The last repeal I'll mention, and this is the big one, is the endangerment finding. So I don't know how many of you are familiar with this. The endangerment finding is a rule issued by the Environmental Protection Agency after a case in 2007 by the Supreme Court called Massachusetts versus EPA. So Massachusetts versus EPA is probably the environmental law decision of the century. Enormously consequential decision that said the Clean Air Act authorizes the Environmental Protection Agency to issue regulations to combat climate change. The Clean Air Act was not really designed for this. It was passed in 1970 and it was modified in 1990 with amendments. And the members of Congress were not really thinking about climate change. They were thinking about pollution. They were thinking about things that you breathe in that harm you. But it regulates pollutants. So the question is greenhouse gas, are greenhouse gases pollutants? The Supreme Court said yes. And therefore, if the EPA finds that greenhouse gas emissions contribute to a public health crisis. If there's an endangerment finding, then the EPA can issue regulations like President Obama's Clean Power Plan, which was a rule that required states to shift to solar and wind energy as opposed to coal and fossil fuel related sources of energy. The Trump administration is trying to repeal the endangerment finding by concluding that greenhouse gas emissions do not endanger public health or welfare. If the administration is successful in repealing this rule, it will certainly generate enormous amounts of litigation, and the courts will probably get involved very quickly. Okay. DOGE is also involved in eliminating federal government jobs at an astonishing rate. It's illegal to fire a government bureaucrat without undertaking an immense effort. Most civil service employees cannot be fired except for cause. The president has personnel authority over 2% of the federal workforce. A federal government job is one of the most secure positions in the world. Historically, about 1/4% of federal employees are fired in a year, 1/4%. This is far lower than the rate of firing in the private sector. DOGE has worked around these civil service protections by using exceptions to the rule. And the biggest one is probationary employees. So probationary employees, these are people who have worked in their positions for a year or two at most. They do not have the same protections as career bureaucrats have. The administration fired 25,000 of these employees in the summer, and just a few days ago, a federal district judge reinstated those employees, saying they were fired without justification. The other category that DOGE has been really focused on is getting employees to accept buyouts rather than firing them. So around 75,000 employees have accepted buyouts rather than accept a change in the terms of their employment, the main one being an end to remote work. And you probably remember reading a lot about this, that Musk was telling everybody they had to go back into the office. Many people just decided to take a buyout rather than accept those new conditions of employment. So the administration has worked around some of the protections by using these creative mechanisms. In total, I think the count is unclear. If you ever read media accounts of how many people have been fired, it's really hard to know. They have a very hard time figuring this out. But something like 150,000 to 300,000 people have been fired so far. While this is a significant number, let's remember it's about the same number as those fired through the Clinton-Gore Commission. Now, maybe there are more firings to come. It's likely that the administration will try to eliminate more personnel. But at this point, DOGE has certainly made a difference, though, again, not unprecedented. Okay, finally, the president has asserted his presidential control over what are so-called independent agencies. The heads of these agencies, as I'll discuss in a minute, are protected by dismissal except for cause. So you can't fire the heads of some of these agencies except for cause. They enjoy something like the job protections that tenured faculty here at UCCS enjoy. Trump has actually fired the heads of several of these agencies without cause, and he's doing this, I think, because he's trying to test the constitutionality of independent regulatory commissions. I'll talk about that in just a minute. Okay, that's my best attempt in a short period of time to describe everything that has been going on through DOGE. It's just in 8 months, it's pretty significant. Why is he doing this? I think this is the thing that most people don't fully understand, and this is the thing I really want to impress upon you tonight. I think the president and the administration are doing this because they have a constitutional objection to the administrative state. So what is it that we mean when we talk about the administrative state? Most people are unfamiliar with this term. Maybe some of you have heard it, but almost everyone is familiar with what the administrative state does. In short, over the past century, most of the power to make policy choices in our national government has moved from elected legislators to administrative officials. Most of the decisions that are made today are not made by elected legislators, but by administrative officials. Climate change regulation, regulation of health insurance plans, regulation of gas stoves, regulation of all of the appliances we have in our kitchens, fuel economy standards, financial regulations, and everything in between. It's the decisions of administrative agencies and administrative officials housed in alphabet soup agencies that determine these policies. And this raises, for me at least, a fairly obvious constitutional question. Is it constitutional to have agencies that issue rules and orders that have the force and effect of law? Even a cursory glance at the basic principles of our Constitution raises this question. Most of you have been taught the Schoolhouse Rock version of American government in high school and college. That Schoolhouse Rock version says, Congress writes the laws, and then the executive branch applies the laws, and then the courts interpret and decide cases related to the laws. We have this separation of powers. We elect representatives who make the decisions in our form of government. And that version of American government is the one that the Constitution establishes. And the framers of the Constitution set it up this way to ensure accountability and to protect natural rights. Ensure accountability and protect natural rights. And they were motivated especially by three principles. One, representation. The form of government we have in America is a republic. You all might be familiar with the famous story, right? In Philadelphia, they close the doors. They don't let anybody hear about what's going on inside the Constitutional Convention. And Benjamin Franklin walks out, and a woman asks him, "What form of government have you given us?" And he famously says, "A republic, if you can keep it." Many of you have probably heard that story. What is a republic? It's a form of government in which we elect representatives who make the laws. We pride ourselves in America on establishing a representative democracy. The voice of the people decides what government does and doesn't do. The principle of republicanism or representation, central to the Constitution. A second principle, because of human frailty, because of human bias, because of the allure of power, the framers of the Constitution set up a separation of powers. If the police officer can make the law and decide who to enforce it upon, then the citizens are subject to the will of the officer, not to the rule of law. And as James Madison wrote in the Federalist Papers, the combination of all three powers in the same hands is the very definition of tyranny. So the separation of powers is the second principle that they enshrine in the Constitution. The third principle, when citizens are prosecuted by the government, when their liberty and property are at stake, they get due process. And this guarantees that the rule of law is followed rather than the blind and arbitrary choices of government officials. These three basic principles, representation, separation of powers, the rule of law, are threatened by the most extreme aspects of administrative law today. And that's why I think the Trump administration is doing what it is doing on all of these fronts. Okay, I'll briefly talk about these three principles, maybe mention a few things about what's going to happen in the courts, and then we can have a conversation about what all of this means for the Constitution and for us today. Okay, so the first problem, the problem of representation. Article 1, Section 1 of the Constitution says, all legislative powers are vested in Congress. The legislative power belongs to Congress. This is the first operative sentence of the Constitution. Why? Because members of Congress are elected by the people, and so they are supposed to be accountable to the people. The essence of that legislative power is the power to make laws. Laws are traditionally understood as rules and measures of action. A rule that you have to follow, and that if you don't follow it, you either get fined or you get thrown in jail. And so a Republican form of government is one where the laws are made by the people's duly elected representatives. Unfortunately, as Ben Franklin feared, we have not kept the Republic. Laws are no longer made by Congress. Now, let me be clear, Congress passes laws today. More appropriately, Congress passes statutes. But these statutes are not laws. They do not contain rules and measures of action. Rather, they give away the lawmaking power to other actors, namely those housed in the alphabet soup agencies. In short, Congress routinely delegates away its legislative powers to the administrative state in violation of this first sentence of the Constitution. This was most evident, and this is, I think, the best example, in the debate over the Affordable Care Act. This is the law commonly known as Obamacare. Infamously, when Speaker of the House Nancy Pelosi was asked about the bill, she famously said, or infamously said, "We have to pass the bill so that we can find out what's in it." Maybe you know this. This was a very kind of significant moment in which people thought she was admitting something, but they didn't quite catch what she was actually saying. Most people misunderstood this statement. We have to pass the bill to find out what's in it. Everybody thought she was saying, we haven't read the bill. That's not what she was saying. She was making a more profound point. She was saying the real decisions are not actually contained in the bill. The real decisions would be made in the regulations promulgated by the Secretary of Health and Human Services, and those could only be issued after the statute was passed. So, for instance, when the question arose about defining contraception and abortifacients as essential health benefits, nobody looked to the Affordable Care Act to see if those were essential health benefits. They looked to the rules promulgated by HHS. This is the typical pattern of how government works today. The rules, the laws, are not contained in the statutes passed by Congress. They're in the regulations established in the Code of Federal Regulations made by agencies. Congress has given away its legislative powers to these bodies. The Trump administration's efforts to repeal rules like the endangerment finding, I think, are motivated obviously by politics, right? The Trump administration's base does not want policies that reduce greenhouse gas emissions. Those were the people that elected, in part, the people that elected him, those constituencies. And the president wants to deliver on his campaign promises. But there's a deeper constitutional issue as well. The Clean Air Act was not designed to address climate change. There were vigorous attempts to get Congress to pass climate change legislation, and those attempts did not succeed. Congress refused to pass climate change legislation. All too often what happens is, even when Congress refuses to pass a new law, the administrative state finds a way to teach an old law new tricks. And the Clean Air Act became a classic example. If Congress doesn't pass legislation to address the president's priorities, the president just finds that authority anyway. He uses a pen and a phone. He finds that authority hiding in some obscure provision of existing law. That's because so much power has been delegated away from Congress. Okay, what about the separation of powers? I've just explained that administrative agencies have the legislative power. They obviously have the executive power. In many cases, agencies also have the judicial power. This is the thing that most surprises people when I talk about the administrative state. Most people are unaware of the pervasive existence of administrative law judges. These are real people that exist in the federal government, administrative law judges. These are people who work inside an administrative agency, and they issue orders deciding individual cases involving the agency's own rules, prosecuted by the agency. And when you appeal from a decision of an administrative law judge, you get to appeal to the agency. It's not just that the agencies are making the rules, the agencies are also trying the cases involving their own rules. Now, Article 3 of the Constitution, as we all know, grants the judicial power to the federal courts, an independent branch of government, and says that judges, who are federal judges, have tenure during good behavior, what amounts to essentially a lifetime appointment, and also that their salaries cannot be manipulated by the other branches of government. The basic purpose of this, of course, is to ensure an independent judiciary. Today, in administrative agencies, most of the decisions, or many of the decisions, are actually decided in-house on the agency's home court. The agencies get a great home court advantage from deciding cases in front of their own judges. Now, to be fair, there are rules in place to protect administrative law judges from their own bosses. The agencies hire their own judges, but the salaries are actually set by a different agency called the Office of Personnel Management. The agency, however, conducts the performance reviews of the administrative law judges that determine whether the Office of Personnel Management gives them a merit increase. In addition, the agency says the people who do the investigating and the prosecuting inside an agency, the Administrative Procedure Act says that the adjudicators can't be the same people as the prosecutors. There has to be a separation between prosecutors and adjudicators inside these agencies. But it's really easy to circumvent these protections. it's very easy to understand that the people who work in the same building with you, who are right down the hall from you, are going to have some influence over how you decide these cases. And this has been shown to be a real problem inside administrative agencies. Even Barney Frank, a liberal Democrat from Massachusetts, observed that there have been allegations from administrative law judges of coercion, threatened transfers to other agencies, and other kinds of pressures so that the judges would decide cases along the lines of what the agencies wanted. Federal agencies achieve remarkable win rates in front of their own courts, which everybody would understand is likely to happen. The Wall Street Journal examined the win rate of the Securities and Exchange Commission in front of its own judges and compared the win rate in SEC cases in front of its own judges to cases decided by independent judges in federal court. The results were significant. The SEC won 90% of cases before its own judges. Shocking. Prevailed in only 69% of cases in federal court over the same period. Not surprisingly, the study also found that the SEC brought 80% of its cases in front of its own judges. And the appeals, as I mentioned, go to the SEC itself. Out of the 56 cases appealed to the SEC from their own administrative law judges, the Commission affirmed its own judges' decisions 95% of the time. One SEC judge, who was known to be lenient on defendants, was accosted by the agency's chief administrative law judge, who questioned her loyalty to the agency and said, "In an administrative proceeding, the burden is on the accused to prove their innocence." This is the chief administrative judge at the Securities and Exchange Commission. Now, there's a recent case called SEC versus Jarkissi, and I can talk more about it in some conversation afterwards if you want to hear about it, that is limiting this power of agencies to use their own courts. We don't yet know the extent of this decision, but I think it could prove to be a very healthy development in restoring the independent judiciary that the founders gave us in the Constitution. Okay, I have one last idea to convey, and then we'll have some conversation. So as I've just said, agencies make law, they execute law, they adjudicate law, they decide cases brought by their own prosecutors, applying their own rules. Agencies are not, in our system, judge, jury, and executioner. They are lawmaker, investigator, prosecutor, judge, jury, and executioner. It is not surprising, then, that President Trump and his supporters would want to dismantle and restructure this administrative behemoth. There's one additional constitutional question that surrounds this administrative state. Where is it located in our political system? Which branch does it belong to? Most people reasonably would say this is part of the executive branch. And that's true for many administrative agencies. So OSHA, the Occupational Safety and Health Administration, is inside the Labor Department. The Bureau of Land Management that I mentioned earlier is inside the Interior Department. The EPA is its own cabinet-level executive agency. The heads of all these agencies can be fired by the president at will. The president can fire the Secretary of the Treasury or the Attorney General like this without needing a reason to do it. We call these kinds of agencies executive agencies. There's another kind of agency known as an independent agency or an independent regulatory commission. And the heads of these agencies cannot be fired by the president except for cause. The Securities and Exchange Commission, the Federal Communications Commission, the National Labor Relations Board, the Consumer Product Safety Commission. You're getting tired of all of the alphabet soup. All of these agencies are independent regulatory commissions. The heads cannot be fired except for cause. That means that these independent agencies are not directly accountable to the president. They serve for a set number of years. The president can't fire them before their term is up. There are Biden-appointed heads of administrative agencies right now, even though President Trump is the president of the United States. And that was true under Biden. Under Biden, there were many administrative agency heads in these independent agencies that Trump had appointed. Obviously, this diminishes the accountability of the administrative state to the president. How do we justify this? There's a famous case from 1935 called Humphrey's Executor versus United States, in which this principle of independent agencies was tested for the first time. And the Supreme Court in that decision said, these agencies are not actually executive agencies. They are, quote, quasi-legislative agencies and quasi-judicial agencies. Quasi-legislative and quasi-judicial. And therefore, the president can't fire them because they're not part of the executive branch. Where are they then? In response to this decision, which infuriated Franklin Roosevelt, he declared that the administrative state, at least these independent agencies, constituted, quote, now this is FDR, quote, a headless fourth branch of government, not contemplated by the Constitution and not responsible to the President, to the Congress, or to the courts. Right? FDR said this was a sort of unconstitutional headless fourth branch of government. This case, Humphrey's executor, is also potentially going to be overturned by the Supreme Court in the coming years if it has not been overturned already. President Trump fired the heads of some of these agencies early in his second term. He fired the head of Consumer Product Safety Commission. He fired the head of the Merit Systems Protection Board. He fired the head of the National Labor Relations Board. All of these people cannot be fired by the statutes creating those agencies except for cause. And Trump said, I have no cause. I'm firing them anyway. Why? Because Humphrey's executor was wrongly decided, and I want the Supreme Court to overturn it. That very well may happen. Okay. Has Doge made a difference? Hopefully I've conveyed to you that the answer to that question is, so far, yes, a huge difference. The administrative state is under serious stress. But the main thing I want to convey is that this is for good reason. The administrative state has existed for a long time, but it has really threatened these core constitutional ideas in ways that we've not fully understood or fully reckoned with. And I think it's a good thing for us to reckon with what the Constitution means with respect to the administrative state today. I think it's a mistake to think of Doge as a department of governmental efficiency. It's not a department of governmental efficiency. It's not trying to make the government more efficient. It is trying to restrain government. It is trying to bring government more in line with constitutional principles. Our Constitution sets up a republic with separated powers and independent courts. We can have regulation within those constitutional boundaries. We can have policy informed by expertise within those constitutional boundaries. We can have regulation. We can have government programs without giving all of the power to agencies filled with people we did not elect. Doge has made a difference in raising these constitutional challenges to the administrative state. What happens next, of course, is up to the American people, and that is as it should be. Thank you very much for listening, and I look forward to your questions. You want me to?
About 15 minutes for questions.
Okay. Yeah.
Do you see the overturning of Humphrey's executor creating a path back for the Congress to stop being so performative, as we spoke about earlier, and more in line with what they're supposed to be doing constitutionally?
Okay, great. So this question, let's say Humphrey's executor is overturned, and now President Trump is in charge of the whole thing. One huge question is what happens to the Federal Reserve? So the case that first tested the legality of these firings is a case called Trump versus Wilcox. The Supreme Court decided on this thing called the emergency docket. You might have heard of this thing, it's the shadow docket, in which there's not full briefing and all that stuff. So the court's opinion in Trump versus Wilcox is very short. It's not really a fully reasoned argument. But the Supreme Court upheld the firings of all of these people, which seems to suggest that Humphrey's executor is either gone at this point, or it is very narrowly going to be applied to only a couple of agencies. And in the Trump versus Wilcox decision, the Supreme Court said, just so you all know, the Federal Reserve is off limits. Trump can't touch it. So it was like they knew. That was like the elephant in the room that we don't talk about. Like Trump will not. We know he's been pressing Jerome Powell to cut interest rates. We know he wants the economy to roar, especially going into the midterms. So the Fed is safe. How the Fed is distinguished from these agencies is another question. But the bigger question you're raising is, if Trump is in charge of the whole enchilada, won't this just make Congress wake up and realize, maybe we were wrong to give all of this power over to one person and put him in charge of the whole thing? I have seen, so I'm going to give you the optimistic and the pessimistic from my point of view answer. And I probably lean more towards the pessimistic side, but I'll give you the optimistic case first. The optimistic side of this is I've seen more people who tend to disagree with me politically speaking up about the dangers of presidentialism that I've seen in the past. I've been talking for a long time about how we shouldn't be giving one person all of this power, and our Constitution seems to say that you shouldn't do that. And most of the time I've not had a lot of allies in making that case. More and more I see people waking up to the dangers of giving all of the power to this single actor in our government. Can you build a bipartisan coalition then on that? I'm afraid the answer is probably no. Most of these people are waiting until their person gets all of the power, and then they are more than happy to have that person make all of the decisions. This is a really sad thing about the state of our Constitution. We're all situational constitutionalists. We love the Senate when we hold the Senate, and we love the presidency when we hold the presidency. We love the Supreme Court when we hold the Supreme Court. It's amazing the kind of mental gymnastics people will go through to change their positions on, say, nationwide injunctions, right? When their opponent is in the White House and they have the courts, and then all of a sudden that changes very quickly when the other party gets the presidency and now they're using the courts to obstruct. It's a really lamentable fact. I don't think the framers would have been surprised at all that people don't think about constitutional process. They think about getting the outcomes that they want. That's why I think education and educational institutions and forming people's character and their intellectual understanding of our political system is the most important thing we can do to protect it. I'll say one last thing about this. Sorry, this is a little soapboxy. The tariff thing. That's another example here where, I don't think, I'll give you my personal thoughts on this. I don't think there's any, I was just fighting with somebody about this at a dinner, law professor over dinner just a week ago. I don't think the emergency statute that Trump is relying on to enact to promulgate the tariffs at all authorizes that. And I think there's this doctrine called the major questions doctrine. The court has frequently used. I think the major questions doctrine is a good doctrine. I think this is a major question, and I don't think the statute gives him the ability to make that call. I was arguing with a liberal law professor who was taking the other side of that case. He was like, yeah, I think the emergency statute actually lets the president do that, which was kind of a bizarre thing. I was like against the Trump administration and he was for it. So I see that possibility. The tariff thing, but look what happened in Congress, right? Don Bacon and Chuck Grassley spoke up. That's like two Republicans. And everybody else seemed to be content to go along with it on one side. So I'm afraid that, the simple answer here is that political parties, in a sense, have overwhelmed the separation of powers. If you're a Republican in Congress and a Republican controls the White House, you don't have checking and balancing, you have collaboration. People are have more allegiance to their party than to their branch of government. And as long as that's the case, it's unlikely we'll see Congress building up its muscles like it used to have. And for me, that's a lamentable thing, but it's something we need to strive to fix. Yeah, in the back there.
So let's say, we already got rid of Chevron, Humphrey gets overturned. Trump starts exerting a lot of power over the bureaucracy. What is the ideal scenario? What's the ideal outcome? You criticize the administrative state thoroughly, and I largely agree. Are you in favor of the complete abolition of the alphabet soup, or should we keep some of our money?
Yeah.
So how do we go with that?
Okay, good. Thanks. Great question. So it helps me to clarify something that I hope I haven't made unclear, but I'm glad to be able to clarify it. I get asked the question a lot, if Postell gets his way and we do away with the administrative state, how much of the federal bureaucracy is dismantled? My answer is, none of these agencies will go away. So what do I mean? How could it possibly be that I've just stood up here and said, the administrative state is like super unconstitutional, and now somebody asks you, well, what happens if you get your way? And I'm like, all of it stays. The answer is, I said this at the very end of my talk, you can have regulation without turning over all of the power to bureaucrats. Congress can enact laws that actually make rules and regulations. And the executive agencies are still there to investigate, to prosecute, to enforce. And you get to go to court if you have a dispute about what the rules are. So I think you would still have an EPA. I think you'd still have an FDA. I'm going to fly tomorrow back home to Michigan. I want the plane to fly. I'm happy to have an FAA that is involved in enforcing airplane safety regulations. I'm not an advocate of laissez-faire. The framers of the Constitution absolutely were not advocates of laissez-faire. If you go back and look at what they did, they had pervasive regulations, but they did it through elected representatives, and they gave you a trial by jury and in a court of law whenever you had controversy surrounding those regulations. So I think you'd put more of the emphasis on Congress to make the rules, and I think you'd want to separate all of these adjudicators and ALJs out into the Article 3 courts. With one huge caveat, there are different kinds of adjudications. So if you read political theory, the difference between executive power and judicial power is very unclear, even to people like Montesquieu and Locke. Let's say Congress creates Social Security, and you have to go in front of a Social Security administrator in order to figure out if you're eligible under like Social Security disability or unemployment benefits. Are you actively looking for work or not? Do you need like a judge and a trial by jury to adjudicate a Social Security eligibility determination? In my view, the answer is no. What's different about Social Security then and a $300,000 fine from the SEC and a ban on practicing securities in the securities industry? The difference is the first one is a public right. It's a right that's created by the government, and the government can use whatever form of process it wants to adjudicate cases involving that right. The other kind of right is a private right. Fining you $300,000 is taking away a natural right to property that the government didn't create for you. And so I would say, when I say that I want judges deciding these cases, I don't mean every little Social Security case. The big area where this is going to get controversial is immigration. Because the immigration courts are one of the most significant parts of the administrative state we have. And the question is the right to come to this country and the right to stay in this country a public right or a private right? And that's where it will get very tricky. The distinction I just sketched out between public rights and private rights is exactly the one the Supreme Court is currently pursuing, but it has been completely unclear about what falls on which side of that distinction. So short answer is, I actually don't think much of regulation and much of the bureaucracy would go away. They would just be executive instead of lawmaker, investigator, prosecutor, judge, jury, and executioner. Yeah.
So, given the separation of powers issues that this whole DOJ situation is kind of really exposed, kind of in the grander scheme of things, where do you think this leaves us in terms of the small R Republican project that you think country is based on? Do you think that the kind of concepts of separation of powers have failed just kind of based on kind of the real practice kind of case studies that we've seen and what's actually happened in government? Do you think it's still salvageable just with structural changes, or do you think there was some kind of fundamental philosophical kind of mechanistic failure that the founders didn't account for when they tried to promote separation of powers? Where do you think that kind of leaves us?
I think the founders did a pretty good job of setting it up, actually, and I think we had separation of powers in this country till about 1905 or 1910. So I wrote a book, Professor Pitts mentioned, Bureaucracy in America, which aims to be an entire history of the American administrative state. Somebody made it actually was made into an audiobook. There are people who have listened to a history of the administrative state while they were driving across the country. I do not recommend consuming the book in that format. But I made the argument that so I fight with law professors about this a decent amount. And there are interesting examples early in American history. The Patent Office, the Post Office, the Land Office, which had to distribute all the claims about public land, a steamboat commission that regulated safety on steamships in 1852. Aren't all of these part of the administrative state? And if the answer to that is yes, then it's been around forever, and the framers probably endorsed it. I sort of, in painstaking, not that bad actually, it's readable. But in some detail, I dismiss all of those early examples, and I think it's really not until the progressive era in American history where you get the administrative state. And the reason you get it is because there's a new philosophy of government that appears in the progressive era that says, we don't really believe in natural rights, we don't believe in limited government, we don't believe in the separation of powers. They're clear about that. You read any of the progressives and they think the separation of powers is a terrible idea. And they openly say it. They're not even like, I'm not straw-manning them. This is just their own views. And so I think the administrative state really is the result of a philosophical change it's not the result of modern circumstances or something the framers might not have foreseen. I think it was really just the Constitution fell into disrepute in the early 20th century, and ideas have consequences. Yeah.
So considering that consolidating power is dangerous, but delegating power is unconstitutional, kind of like what is the solution here? Do you think that there's a world where administrative branches can exist and they can regulate, or do you think that Congress is responsible for creating every single law, every single rule, you know what I mean?
Yeah. Yeah, maybe the sort of thrust of the question here is like, do you really expect Congress to wade into all of these questions?
To introduce every single thing and it gets through committee and it gets to the whole.
Yeah. Yeah, I want Congress to be involved in making sure the airplanes are safe to fly. These people can't tie their own shoes, much less figure out if we should approve some new drug for some new experimental treatment, or how many parts per million of sulfur dioxide should be in the air, right? The answer, I hate to, I set it up pretty badly for my response. My answer is yes. I do think Congress should do this. Now, the argument for that would be, if you really want to manage the administrative state, you need like a lot of people with like a committee system or some form of like specialization in which these people gain like real knowledge of what's going on in these programs. You need people who are around for a lot longer than 4 or 8 years. And you need them to be able to like bring in the experts as witnesses and hold things like hearings where they would ask questions of these witnesses and inform themselves as to what's going on. You know what's a great body for that? Congress. Congress has committees. It has hearings. There are a lot more people there than the one guy in the executive branch who's supposed to manage the whole thing. I think Congress's institutional capacities are far greater than the president's for making these decisions. But in order to do that, you'd have to get Congress to stop doing what it does in congressional hearings, which is trying to insult each other or the witnesses in order to score points so that they can cut a video so that they can raise funds for the next election. But in part, like, you get the government, you pay for, what's the right way to, we get what we deserve. If we don't ask Congress to make the laws, they're going to start doing other things. And I think in part, like, they're just responding to us and what we reward them for doing. So I think if we really followed the Constitution, if we had like a civic culture that believed Congress should write the laws and we really rewarded them for doing that instead of what it's doing now, they might actually start doing more of that. But also just turn off the cameras in the committee hearings. I testified before the House Judiciary Committee when I was a faculty member at UCCS. And I remember I study and teach about Congress, and I've been doing so for many years when I testified. And I was still amazed at the just complete inefficacy of the whole process. Some guy came in, so every member gets 5 minutes to question all of the witnesses after they give their own testimony. And this guy came in like, 2/3 of the way through the hearing, right when it was his time to be called upon. He gave a 5-minute speech, got up and walked out before any of us had even responded to it. Like, that's not Congress deliberating. That's not Congress informing itself about policy. It was a member giving a speech. So part of it is we need to fix Congress. And that's why my next book, shameless plug, will be about how to fix Congress. Because I think that's how you get the administrative state back inside of the constitutional boundaries I've sketched.
Maybe one more shortish question.
I'll try to be short. Yeah.
So you talk about how some agencies will present like the laws in front of their own judges to get like bias on that. How are they allowed to do that?
The Supreme Court has not enforced Article 3 of the Constitution. In that case I mentioned before, that Jarkissi, SEC versus Jarkissi case, the court is starting at least to try to carve out, like, if you're going to do this, you need to go to Article 3. The case was decided on Seventh Amendment grounds, which is the right to trial by jury. But it was basically, if you're getting assessed a big civil penalty, you need a trial by jury, and administrative law judges don't give you a trial by jury. Can I have 30 seconds to tell a story just about this? So, Professor Pitts is the taskmaster here. So,
The body language.
yeah, no, I pick up on these cues. A friend of mine who's a lawyer who does a lot of work in this area, he was telling me this story just very recently about the Consumer Product Safety Commission. So if you've ever seen those voluntary recalls, whenever there's a toy, product that causes a defect, that's the CPSC getting involved in strong-arming a company into voluntarily recalling a product or getting really hammered by the agency. And the CPSC tries its own cases in front of its own judges, but it actually borrows judges from the other agencies. So they're like SEC ALJs that adjudicate cases for the CPSC. And you walk into the CPSC, and you're the counsel defending your client. And you see over there the CPSC person who's brought the case. You see the judges up there who are working for the CPSC. And you see this banner, or it's actually etched into the courtroom, and it says, "Protecting the American people from harmful products." It's like the whole thing is very clearly slanted in one direction. It's really hard for any lawyer not to be intimidated in that kind of an environment, and it's clear that that affects kind of the biases here. So this is real. It actually affects the way things happen on the ground. All right, that was only 30 seconds. Oh, man. All right.